Now, as we were talking of Enforcement Directorate searches at the residence of Sanjay Singh and the Aam Aadmi Party saying that the Enforcement Directorate is being misused by the central government, the Supreme Court, meanwhile, in another case, has given some very strong observations with regard to the Enforcement Directorate. Now, while setting aside the ED arrest of M3M Group's directors and ordering the immediate release of M3M Group directors, the Supreme Court has said that the Enforcement Directorate action is expected to be transparent and the Enforcement Directorate not expected to be vindictive in its conduct, and the ED must be seen acting with utmost probity. My colleague Arvind Gunasekar is with us. And Arvind, these are important comments coming into the backdrop of opposition leaders saying several times that the Enforcement Directorate's actions are not transparent. The Supreme Court importantly has also said that people can't be arrested simply because the agencies say, the ED says that they are not cooperating, and that's important because that's been cited in the arrest and in rejecting, in calling for custody of several leaders.
Yeah, Priyanki, in a scathing remarks on the conduct of Enforcement Directorate, Supreme Court has come down strongly on the Enforcement Directorate. In fact, like you mentioned, the Supreme Court, this particular case pertains to M3M group of companies, both Pankaj Bansal and other director of the company, both of them were arrested by the Enforcement Directorate, and challenging their arrest, both the accused had moved the Punjab and Haryana High Court. Punjab and Haryana High Court dismissed their pleas challenging the arrest, and subsequently they moved the Supreme Court. So they made an argument before the Supreme Court saying that both of them have been arrested in the second ECAR, the second money laundering case that was registered just 24 hours back. And this is a case of clear vindictiveness on the part of Enforcement Directorate, because in the first money laundering case, both of them have been given protection by the High Court. So subsequently, within a short span of time, one more ECAR was registered, one more money laundering case was registered by ED, and both of them were arrested. And that seems to be the case on the ground which they moved the Supreme Court, wherein they also argued that they have not been given the grounds on which they were arrested by the Enforcement Directorate. And that's why Supreme Court has come down heavily on the Enforcement Directorate, saying that Enforcement Directorate cannot merely arrest someone saying that that particular person is not cooperating with our investigation, so we are proceeding to arrest that particular person. That's why the Supreme Court has said that Enforcement Directorate should provide the grounds on which they are arresting the accused. That has to be given in writing to the accused so that the accused can take appropriate legal recourse. Enforcement Directorate cannot merely say that someone is not cooperating when we summon him or her, and based on that we are arresting, cannot be a ground anymore. And Supreme Court has also said that Enforcement Directorate, it is not open to the ED to expect an admission of guilt from the person summoned for interrogation. So all this while we have been seeing several cases that Enforcement Directorate default ground for arresting anyone would be a simple answer that we summon someone, he is not giving answers to us, he is not providing true facts to us, so he is not, she is not cooperating with the investigation, so we are proceeding to arrest. That has been the ground for Enforcement Directorate in several of cases that we have seen, and that's why Supreme Court has come down heavily on ED, saying that you cannot do that anymore. You have to provide reasonable grounds.
So very strong comments made by the Supreme Court.